This episode is brought to you by Shopify. Whether you're selling a little or a lot, Shopify helps you do your thing, however you cha-ching. From the launch your online shop stage, all the way to the we just hit 1 million orders stage. No matter what stage you're in, Shopify's there to help you grow. Sign up for a $1 per month trial period at shopify.com/special offer, all lowercase. That's shopify.com/special offer.
Ryan Reynolds here for, I guess, my 100th Mint commercial. No, don't. I mean, honestly, when I started this, I thought I only have to do like 4 of these. I mean, it's unlimited premium wireless for $15 a month. How are there still people paying 2 or 3 times that much? I'm sorry, I shouldn't be victim blaming here. Give it a try at mintmobile.com/save. Whenever you're ready.
$45 upfront payment equivalent to $15 per month. New customers on first 3-month plan only. Taxes and fees extra. Speed slower above 40 gigabytes. See details.
Atheists, agnostics, long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government, hug the government.
Welcome to The Politics Guys, a place for bipartisan, rational, and civil debate on American politics and policy. I'm Northern Kentucky University political scientist Michael Baranowski. I'm joined today by my conservative counterpart, Cleveland area attorney and defender of freedom, Jay Carson.
Hey, good morning, Mike.
Hey, Jay, how are you?
I'm good.
Yeah, I'm
waking up now after the first.
That helps. Yeah. Kind of.
When we started this, I was just really kind of dragging. But coffee's kicking in, and the adrenaline, the thrill of the fight, the whole bit.
There you go. Yeah, absolutely. That'll get you going. So I mentioned that now that as you know, Jay, a few weeks ago, for the first time, we had recreational pot sales in Ohio, right? And so I wanted to wait for the furor to die down with all the people from Kentucky flooding into southern Ohio and so forth. But now, finally, I think there's an opportunity for me to stop getting my, various THC components from the gas station, and actually kind of strange, unregulated stuff. And if I want, now I can just drive down the street and pick up as much high quality, highly regulated, higher priced, marijuana products that I want. So there's always that I could, so there's, I know how you feel about that. That
stuff will rot your brain.
Yeah, there you go. You're going to stick with alcohol like a good traditional.
No,
American.
I know. Well, I'll tell you, Mike, I've actually, reduced my alcohol consumption considerably. Not that it was that high to begin with, but I'm sort of just, it's more just kind of like a get in shape kind of thing, sure, right? Yeah. As opposed to.
Absolutely. A lot of empty calories there.
It's exactly, yeah. But
you will not be taking yourself down to your local dispensary and loading up on vapes or edibles or anything like that.
I will not, Mike. Okay. I don't need drugs to have a good time. But
all right. Well, Jay's a more or less straight arrow. Whereas I just give me a handful of whatever you got. I'll try anything twice, I guess. There we go.
Right.
Yeah. As Jay knows, that's gotten me in trouble more than a few times in our long association. But all right.
Right.
Let's go. Let's start.
And as expanding this, the greater that, of course, the years from now, the taxpayers will generously bail out and pay for all the damage and conditions brought about by the great healing substance of THC. So.
Yes, and this is me not getting into an argument about the relative merits or issues with alcohol versus THC, right? Which we will table from. But anyway, I thought we could start off with a story that we initially covered back in late April when the FTC announced a rule banning non-complete clauses in contracts. Because at the time,
non-compete contract.
Yeah. Did I say that?
Non-complete.
Oh, non-complete.
Yeah. They still want you to complete them.
Yes, exactly. At the time, the chair of the FTC, Lena Khan, said, well, these are bad things. They keep wages low. They suppress new ideas. They rob the American economy of dynamism. So basically, if you're a fan of low wages, old ideas, a stagnant economy, you should love non-compete agreements, right? Now, you and I discussed this on the show back then. And one of the things we talked about is we said, aside from any substantive merits to the ban, there would almost certainly be legal challenges concerning the FTC's authority to enact a non-compete ban. And that's exactly what happened. And this last week, a federal judge in Texas struck down the ban is with U.S. District Judge Ada Brown, a 2019 Trump appointee to the bench. She concluded that the agency lacked the statutory authority to do what it did. Now, Brown didn't conclude that non-compete agreements are perfectly fine. They may, in fact, qualify as unfair methods of competition under the FTC Act. But as Brown sees it, while the FTC can bring complaints against companies that use non-compete agreements on a case-by-case basis, it lacks the authority to issue a general rule that bans the agreements outright. Now, prior to this, there was a federal judge in Pennsylvania, Kelly Hodge, who's a 2022 Biden appointee. Judge Hodge came to a different conclusion, finding that the FTC Act did give the agency the authority to put in place the non-compete ban. I mean, really, kind of the crux of this matter is differing interpretations of Section 6G of the FTC Act, Section 45, I believe, which gives the agency the authority to make rules and regulations for the purpose of carrying out the provisions of this subchapter. Now, Judge Brown saw this as a so-called housekeeping provision that relates to internal agency organization procedure, that sort of thing, as opposed to something that allows the agency to issue substantive rules, whereas Judge Hodge in Pennsylvania said, no, there's no indication this was a housekeeping provision. Judge Hodge pointed to 26 prior occasions where the FTC used this subsection to promulgate substantive rules, as well as a D.C. Circuit Court opinion from, I believe it was 1973, which concluded that the plain language of 6G gives the FTC the authority to make substantive rules and regulations. Now, there is one important difference, as you point out, between these rulings. Judge Brown in Texas ruled on the merits. Judge Brown issued a summary judgment for the plaintiffs against the FTC, whereas Judge Hodge's ruling was a denial of a stay for the rule. So it wasn't on the actual merits of the case. And this rule actually has never actually gone into place because it was scheduled to take into effect in early September. Now it's on hold. There'll certainly be an appeal of this by the FTC. My guess, Jay, is that the Fifth Circuit, which is the most conservative appeals court, is likely to agree with Judge Brown. That's where that appeal will go from that Texas district court judge, at which point the Supreme Court may or may not decide to take it. My sense is that if the court did take it up, probably there would be the votes to uphold Judge Brown's ruling in the end. But what's your view on, I guess, both on the rulings here, as well as how this might end up playing out as it maybe works its way up the appellate ladder?
This episode is brought to you by Shopify. Whether you're selling a little or a lot, Shopify helps you do your thing, however you cha-ching. From the launch your online shop stage, all the way to the we just hit 1 million orders stage. No matter what stage you're in, Shopify's there to help you grow. Sign up for a $1 per month trial period at shopify.com/special offer, all lowercase. That's shopify.com/special offer.
Feel your max with Brooks Running and the all-new Ghost Max 2. They're the shoes you deserve, designed to streamline your stride and help protect your body. Treat yourself to feel-good landings on an ultra-high stack of super comfy nitrogen-infused cushion that takes the edge off every step, every day. The Brooks Ghost Max 2. You know, technically, they're a form of self-care. Brooks, let's run there. Head to brooksrunning.com to learn more.
Whoa. Landing an account this big will totally change my landscaping business. It's going to mean hiring more guys and more equipment and new trucks for the new guys to drive the new equipment in. I don't know if I'm ready.
You can do this, and Ford Pro FinSimple can help. Our experts are ready to make growing pains less painful for your business with flexible financing solutions that meet the needs of your business today when you need them. Get started at fordpro.com/financing.
So, as you might expect, I think Judge Brown gets it right in that. And one, I don't disagree that the FTC can promulgate substantive rules. I would disagree that they could promulgate substantive rules based on what they presented. In terms of, is it arbitrary, capricious? Does it violate sort of the APA? Does it violate? Is it a major question when you're saying that this agency is going to, by rule, do something that, look, heretofore was always done by statute, by state legislatures, and which brings me back to the other point of, look, there was a whole state regulation system of these agreements that was working just fine. But yeah, so I think I think the Texas court got it right. I think it probably does end up going to the Supreme Court eventually. It'll probably be a year or two, because I think what'll happen is the court in Pennsylvania will likely issue a ruling on the merits eventually, coming out the other way, and then they'll both go to Pennsylvania will go to the Third Circuit, Texas go to the Fifth. Don't know what the Third Circuit would do, but I think you'll end up with a circuit split, and you end up going to the Supreme Court. And I think the court probably says no, that the FTC does not have that broad of regulation. There was an interesting thing in the Pennsylvania decision. There was one line, which to me, it's sort of, that's where the court went astray. It was a line about, well, the statute, really doesn't put any limits on what the FTC, can do. And again, that struck me as, look, you're reading this the wrong way. A creature of statute, typically under the law, can do only what it is specifically empowered to do. And even then, it's always subject to the Constitution, and separation of powers and all these other, now that the new Loper-Bright, doctrine, getting rid of Chevron, so that there's not that to hang their hat on anymore. Of the major questions doctrine announced in West Virginia versus EPA. I shouldn't say announced, but I guess kind of came to full bloom in West Virginia.
No, announced would be fair, because that's the first time that really the court came out and basically said that this was a standard they were going to.
That's what I think that was the first time. It's not the first time I think major questions has been talked about or raised. Right. I think it's the first time that a court had decided a case on that basis, formalized in that way. Right? Yeah. I mean, I think a lot of times it's sort of it was sort of and also, we come out this way, and also we think that it's a major question and shouldn't. But yeah, that was anyway. So I think that's where we are. Yeah, I think it's. I'm torn. I guess my concern, right, is that, listen, if you do have these agencies that can, and part of the problem is also whether it's prospective or retrospective, rewrite private contracts that have been entered into. That's a problem. It's one thing to say we're going to ban these types of relationships going forward. I think that's still a problem, but that's more a policy problem than a legal problem. And it gets back to, look, if Congress wants to do this, it certainly can. But, and then you can have the policy debate, whether it's good, bad, or whatever. So either way, I still come out of this was sort of a problem or a solution in search of a problem to begin with, given that we've got a situation where you've got a number of states right now, California, for example, does have an absolute ban on non-competes. And look, whether that's a good idea or a bad idea, it's completely within the power of the California legislature to do that. And likewise, other states have sort of these, interim things. And if not, then it falls back to the case law. And there's sort of a whole big, judicial body of law set up about how to deal with this. And, typically a non-compete can only be enforced to the extent it is reasonable and protects a reasonable interest. The mileage may vary from state to state on that, but yeah, I think this is more about the FTC seeking to project power than to solve any particular problem.
Well, on that, I disagree with you a whole lot. I want to come back to that because I first want to get to the point where maybe I agree with you a little bit more. And when I read the Pennsylvania ruling, I think that Judge Hodge made some good points, saying, well, we do have some precedent here from an appellate court. The D.C. Circuit said, good to go, using 6G as authority. Okay. And the FTC has done it a bunch of times. It's said 26 times. So based on that, that's not an unreasonable conclusion to draw from that. But then when I went back to the statute, I'm inclined to agree with Judge Brown, the Texas judge, because that 6G is in a section entitled additional powers of the commission, which I read the entire section. To me, it feels very, very housekeeping-like. And so I think, to me, the stronger argument is if Congress had intended for the FTC to have this specific authority, they would have put it in, say, like Section 45, because Section 45, which is the section, I believe, before that, unfair methods of competition, unlawful prevention by commission. That's where you put that kind of statutory authority. The
legal principle, Mike, I'm going to throw out the Latin because I can. Sociis noscitur, which means it will be known by its associates, by its colleagues. So, yeah, the placement matters. If you put if you put something, you review it in terms of what else is around it in context.
We hope you enjoyed this preview of our supporters exclusive midweek show. If you'd like to hear the rest of the episode, we hope you'll consider becoming a supporter. Supporters get ad-free access to all of our shows, membership in our Politics Guys Discord group where you can join in on the conversation, and other benefits at different levels of support. To become a supporter, go to patreon.com/politicsguys. You can also support us through Venmo or @politicsguys or through PayPal. You'll find all of our support links in the show notes as well as at politicsguys.com/support. And if you'd like to get the midweek show, but you're not in a position to become a financial supporter, that's not a problem. Just send me an email at mike@politicsguys.com, and I'll be happy to get that set up for you.
This podcast is part of the Democracy Group,